A latent defect is discovered during the home inspection, and the buyer terminates the contract. The seller repairs the latent defect, and the agent puts the home back on the market. Must the agent or owner disclose the past defect to any future buyer or agent?
Under Maryland law, sellers must disclose known latent defects. Latent defects are material defects in real property or an improvement to real property that 1. A buyer would not reasonably be expected to ascertain or observe by a careful visual inspection of the property, and 2. Would pose a direct threat to the health or safety of the buyer. However, where a seller remediates a latent defect and maintains that the item is no longer defective, no disclosure is required by the seller. Licensees must disclose material facts that they know or should know that relate to the property. A material fact is defined as a fact that a buyer would consider important when making the decision to buy the property or on what terms and conditions to buy the property. The fact that a latent defect was found and subsequently remediated is material and should be disclosed. The listing agent or broker should disclose that a latent defect had been present in the property, but that the seller remediated it. Although not explicitly required, we strongly recommend that material facts be disclosed in writing. The Maryland Real Estate Brokers Act and the Code of Ethics of the National Association of Realtors both provide that it is the obligation of a real estate licensee to ascertain and disclose all material facts to all parties of which the licensee has actual knowledge or those which the licensee should have known that relate to the property. As a real estate licensee, it is your responsibility to protect and promote the interest of your client, the seller, to protect the seller from subsequent litigation by the purchaser, and coincidentally, to protect yourself. We believe that whenever you are in doubt, it is best to disclose.
I have a listing that is under contract and was supposed to settle 2 days ago. I have heard nothing from the buyer's agent requesting an extension of settlement. Can I put the property back on the market as active?
The time is of the essence paragraph at the top of page 1 of the MAR contract permits a party to unilaterally terminate the contract when the other party fails to perform required actions within a certain time frame. When a party fails to perform within a certain time frame, the contract becomes voidable for the non-defaulting party. In other words, the non-defaulting party may cancel the contract. However, the contract is not considered canceled or void unless the non-defaulting party notifies the defaulting party in writing. Where unilateral termination is permitted in the contract, consent of the other party is not required. The agreement is no longer binding, and the parties have no further obligation to perform. The non-defaulting party may use the MAR Unilateral Notice of Termination form for this purpose. This form does not require the buyer's signature. Once the seller has sent the unilateral notice of termination to the buyer, the seller may begin remarketing the property. As an example, under paragraph 10 of the contract, the buyer is required to apply for financing and obtain a written financing commitment within a certain time frame. If the buyer did not meet one or both of these time frames, then the seller could unilaterally terminate the contract because the buyer failed to satisfy his or her financing contingency in a timely manner. Of course, the buyer may disagree with the seller's rationale for voiding the agreement. We make no representation regarding the buyer's ability to pursue legal and equitable remedies against the seller. In this regard, it is important that the parties understand that if a party exercises the right to terminate the contract, the other party is not precluded from pursuing any legal and equitable remedies that the other party believes he or she is entitled to.